up we have Hans Bennett, a journalist and an organizer of journalists for Mumia, and he's going to give us a little bit of a legal update. And he's an amazing man, very, very strong. Here you go, everybody, Hans Bennett!
Hey, nice to see everybody out here. Well, as we all know, there was an awful decision on April 6th denying Mumia a new guilt-phase trial. I need to make this real short because there's so many great people that are going to perform tonight. So if you want to learn more about this, Journalists for Mumia, my group has a website, Abu-Jamalnews.com. Is where you can read more about it. And I also wrote an article for the San Francisco Bayview newspaper on the 6th, laying out this issue. So, really quickly here, there's two issues. The district attorney is appealing so that they can execute Mumia without giving him a new sentencing hearing. Now, in 2001, the U.S. District Court ruled that because instructions to the jury by both the judge orally and on the forms themselves, because those were confusing, that Mumia's penalty was overturned, or so-called overturned, because he's never left his death row cell. Because the district attorney appealed the decision in a particularly sadistic way so that he would never leave his cell and get so-called privileges like contact visits with family and other things. So in 2001, the court ruled that if the district attorney wants to reinstate the death penalty, they have to give a new sentencing hearing. This new sentencing hearing would have a new jury and all evidence could be admitted, including evidence of innocence. But the jury could only decide between life in prison without any chance of parole, which just sucks, or reinstating the death penalty. But it's interesting because, like I said, evidence could be presented of innocence, and this stuff could be put on the record. Now, in 2008, the Third Circuit Court ruled unanimously to uphold that verdict. And the district attorney is currently appealing that to the U.S. Supreme Court, and they want that ruling in and of itself overturned so that then Mumia can be executed without the benefit of the new sentencing hearing. So it's very important for us to get that message out that Mumia is still on death row, and the DA is still trying to kill him. And notably, the Third Circuit rejected Mumia's appeal for a new guilt phase trial, okay? But they have yet to rule on this issue of the penalty. They're holding off because there's another appeal going on in another case which has a similar issue, and they say they're waiting for that. Okay. So let's switch to Mumia's appeal for a new guilt phase trial. This was the Third Circuit Court in March 2008 had a split decision. There was three issues. On one of the issues, which is called the Batson precedent from 1986, Batson versus Kentucky, the judges split 2-1. And the dissenting judge, Judge Ambrose, made a very strong dissent, and he explicitly stated that the court had created a new standard to deny Mumia a new guilt phase trial or a preliminary trial that could have led to a new guilt phase trial. This is a very strong statement, okay? What Batson says is if the defendant can show that just one juror was excluded because they were not white or because for racial reasons, which in this case would be to exclude black jurors, then the defendant is entitled to a new trial entirely. Now, the judge, Judge Ambrose, in his dissenting opinion, he said the fact that the prosecutor McGill used 10 out of 15 of his peremptory strikes, which is where you get to strike somebody without giving a reason, okay, that he used the strikes to strike otherwise qualified jurors. The fact that he used 10 out of 15, using 2/3 of his strikes to do that, in and of itself was enough evidence to get a preliminary hearing on this Batson issue, okay? Now, another reason they gave for denying this Batson ruling was they said that the court, that Mumia's team did not provide enough evidence of the composition of the possible jury pool as far as the racial composition. But get this, in 1995, at the PCRA hearings before Judge Sabo, who was the same judge from 1982, who was in 95 deciding whether or not that 82 trial was fair, Okay, at this PCRA hearing, Mumia's lawyers tried to call 2 different people who were officials from the city and from the county to testify about the racial composition of possible jurors. Okay, and guess what happened? They tried to enter it in, the judge blocked it, he said you can't enter this into the record, and he arrested his lawyer, Rachel Wolkenstein, who was his lawyer at the time. They came and they arrested her right there in the courtroom. And then the judges today cite this lack of evidence that couldn't be admitted as their so-called reason for denying him. This is an outrage. Lastly, Mumia's attorney is filing an appeal for a rehearing, and that's going to be filed at the end of the month. So right now, we need to give this pressure. We need to do everything we can. There's a German petition being signed. There's a petition from the San Francisco Mobilization to Free Mumia, and there's a campaign to contact Attorney General Holder saying we need a civil rights investigation. And that's what we need to do right now to help Mumia's court battle, apply pressure, and fight. Thanks a lot.